I erred in my question in the first case, so I'll just blunder again. Are you related to the plaintiff?
Yes, Your Honor, he's my brother.
Fair enough. Just needed to scratch the curiosity.
Not too many Tinocos in this world, but yes, we're brothers.
All right, sir, you're good. You have the floor.
Thank you, Your Honor. May it please the court, my name is Francisco Tinoco, and I represent appellant Rafael Tinoco in this case. I would like to first make a preliminary statement, if I may. There was a real human toll to appellant Rafael Tinoco from his wrongful arrest. The wrongful arrest of Mr. Tinoco had consequences to him, his family, his career and education, economically and psychologically. The criminal case was dismissed by a no bill from the Hidalgo County, Texas grand jury. Mr. Tinoco no longer faces criminal exposure in this case, but that does not undo the harm that has already been caused in this case and continues to this day by his wrongful arrest. From Mr. Tinoco's perspective, he was wrongfully arrested. His arrest at the high school was planned and coordinated by the Hidalgo, Texas Police Department and with the local media. In South Texas, we have many small cities and communities that are united by geography and also share the same media market. His mugshot was used countless times in the local news media and even in the national education news and in legal blogs. Imagine the headline, "Principal Arrested." Mr. Rafael Tinoco was targeted, smeared, and forced to suffer shame and humiliation because of the actions of the city defendants and the officer defendants. He was unable to leave his house for an extended period of time because of the shame of being exposed in all the local media. Because
so
of
I understand he was probably very upset about that, but hasn't he been able to put on social media, no, it was fake and I'm not being prosecuted?
I don't know how you would do that, Your Honor. It's all already posted. It's already on there.
Right, but what I'm saying is people don't just read one day and never look at it again. So if that was out there, and then no, then wouldn't that be something that would at least cubby him?
It does, Your Honor, but the harm is already there. The thing that first people read is Principal Rafael Tinoco arrested, tampering with a witness. They don't normally go on to see that the case was no bill. Most people don't know what a no bill is from the grand jury. They understand. I don't even know that they would go on to read the rest of that story, Your Honor. But I can tell you this, his career has been derailed. He's no longer the principal at the high school. Every time he applies for a job, he has to put that he has been arrested for this. So to say that, the harm is no harm, no foul, I don't think that's the case, Your Honor. So in this case, where he filed Section 1983 claims against the officer defendants under the Fourth Amendment, which is the right to be free of unreasonable seizures, and the 14th Amendment, the right to due process secured by the Constitution. I think in this case, we have similarities to both Malley v. Briggs and to Franks. The fact that the city of Hidalgo has not provided the video affidavit of Guadalupe Amaya, I think speaks volumes in this case. I believe the Malley harm here is that the officers did not have sufficient probable cause. If you look at the affidavit that was provided by the officer, you'll see all the holes and all the misstatements, misinformation, incomplete information, bogus charges, trumped up charges. The facts just don't really add up to the charges in this case and the probable cause. So I think that the affidavit does lack sufficient indicia of probable cause to render official belief in its existence and makes it unreasonable. So any officer who would have seen this affidavit would know that there's no probable cause in this case. Any reasonable officer. So I think we have the Malley harm in this case, and that subjects us to the not to have the independent intermediary doctrine in this case. Although the magistrate judge, the municipal judge, did sign the probable cause affidavit, the warrant, they should have known they didn't know that the affidavit was tainted by the officer. So I think at least at minimum we have a Malley situation in this case, because the affidavit contained no facts on coercion, bogus charges, incorrect definitions or information about official proceedings, official meetings. And again, the facts don't meet the elements of the charge of tampering with a witness. But I think if we go further, if we're allowed to do discovery in this case, I think we will run into the situation where this is actually a Franks v. Delaware situation, where the officers, either with the coordinated efforts of Mr. Guadalupe Amaya and others in the community, to bring back the soccer. This all started because the soccer coach was taken away from his position. Trying to get the soccer coach back into his position, I think we'll find that this particular police officer, who's been known to do this kind of stuff, to trump up charges against people and citizens in his community, he's been known to arrest people without probable cause. He's been known to not read the Miranda rights to the citizens. He's been known to change information on probable cause affidavits. I think we're going to end up with the Franks v. Delaware situation, that the information that was provided on the probable cause was either invented, changed, or somehow coordinated with Mr. Guadalupe Amaya. And again, I think that would get us past the 12B6 motion in this case and allow us to do discovery so that we can come to a head on this issue. Also, the affidavit in question included material misstatements. The affidavit states that Guadalupe Amaya stated that he did not witness an assault of a student. The statements provided by Guadalupe Amaya were in relation to an official proceeding. Well, what official proceeding are we talking about? What official meeting are we talking about? Principal Tinoco was conducting his own investigation, internal investigation, as to what parents had addressed to him that the coach, athletic director Stumbaugh, had said offensive language and had yelled at the students for their efforts in not wanting to participate in a soccer game. So when the parents approached Principal Tinoco, he did what he has to do. He started an internal investigation. At no time was his internal investigation interfering or reflecting in any way with any police department investigation. These were separate matters, and the police officers knew this, of course. In the statements provided by Guadalupe Amaya to Principal Tinoco, he stated that he did not see the coach grab anyone in the locker. So this is a fact that was already provided to the principal in this case. Now, aside from the many holes and many problems with the affidavit, we also have the issue of the police department. In this case, the police department conducting their investigation, they covered up cameras in the witness rooms with blue gloves. They recorded the witnesses using personal cell phones. And obviously, they trumped up charges with this probable cause affidavit that any reasonable officer would know no charges should have been filed against Principal Tinoco. And in the case of Mr. Stumbaugh, Coach Stumbaugh, his case was also no-billed by the Hidalgo County Grand Jury. We are really only looking for answers, Your Honor. We're looking to see what happened, what was at the cause of this. Something went really wrong in this case. It shouldn't have happened. So we're just asking for the opportunity to conduct discovery. We've tried requesting FOIAs. The city and the state have told us, no, you can't have access to those documents. We've tried Rule 202 depositions under Texas law to conduct the depositions of the witnesses. We were told no, plead to the jurisdiction by the city. So really, we don't have the complete picture, but we do have enough to indicate that the officers did not have probable cause in this case. And I think we do have enough to say or indicate that at least the police chief, the chief of police in this case, was aware of everything and
But the magistrate judge granted the warrant, right?
I'm sorry, Your Honor?
The magistrate judge granted the warrant.
Yes, correct.
So isn't that quote enough?
The warrant itself it's not enough because it was tainted. It was tainted by misstatements, misinformation, lies. You know, this court recently held the officers should know that they cannot lie. In Hughes v. Garcia and Few, this was a similar case where the police officers changed the affidavits in that case, and we believe we have the same case. Any questions?
Yes, I have one question. With regard to the warrant itself, the it attempts to to allege a threat. Is that correct?
I'm sorry?
The affidavit supporting the warrant, it attempts to allege a threat, or what's the basis of that?
No threats, Your Honor. The warrant says
What's in the
that
affidavit?
the affidavit says, well, the police officer's affidavit says that Principal Tinoco asked Guadalupe Maya to change the statement.
Okay, right. Go to 3605A, and as you know, you're familiar with that, the Texas Penal Code, and its definition of coercion. You have a series of things: a threat, however communicated, inflict bodily injury, to accuse a person of an offense, to expose a person to hatred, to harm the credit, to take or withhold action as a public servant, or to cause public servants to take a hold of action. The question is whether or not, I'm going to the question of the validity of the warrant itself, which is what I understand you were arguing. And I wanted to zero in a little bit on the Texas law with regard, in that regard, and to the Texas Penal Code. And my question is, as I understood what he did, he told him that you need to make a correction. I think that was the statement. You need to make a correction.
Correct. It was that he should correct his statement.
Right.
Or add a second statement.
The question is where this fits under the basis of the warrant itself.
My response is no, Judge. The warrant itself does not refer to any threats, any coercion, any forcible action, none of that.
All right. I'm sure Counsel Officer will have some observations about that, but we'll go back and revisit that, because I'm focusing in particular on the question of the presence of a threat or not, as required by the code, which is a part of this goes to the validity of the warrant itself.
Correct, Judge. There was no threat. There was no threats involved, and nothing of a threat was put on the warrant.
Well, let me be more specific. Threat is a defined term. It enumerates a number of things. To commit an offense, to inflict bodily injury, to accuse a person of an offense, to expose a person to hatred and ridicule, to harm the credit or business of him, or to take or withhold any action of the public service, etc. So my question is, that's the only question I had about the warrant was specifically, that's the only arguable point I could see about a warrant, but I wanted to get that on the table.
Thank you, Judge. And I think also the official meeting, the official proceeding, having one of your school employees sign a statement that's not in any official proceeding, any official meeting, how that's defined by statute. As it wasn't even before a notary, it wasn't notarized, it wasn't under oath, it wasn't sworn. It wasn't a statement that was given to the police directly. It's something that was part of an internal investigation. So even on that basis, I think the warrant is facially defective.
All right, thank you.
All right, well, you've reserved your rebuttal.
Yeah, I reserve. Thank you.
Thank you, sir. All right, hear from the city, Mr. Escobar first.
Good afternoon, Your Honors. My name is Carlos Escobar. I represent the appellee city of Hidalgo. I'm going to be addressing the Monell claims against the city and also the failure to screen hiring and training claims. Co-counsel, Mr. Lopez, is going to handle the remainder of the claims, but I'd like to first just speak to the court about I believe, Mr. Tinoco's argument, and a bunch of what he said are based on, conclusory allegations that don't have the underlying facts to support them. And we're asking this court to affirm the district court's judgment dismissing this case because there's a very large lack of specificity in terms of him being able to allege a plausible claim for relief. And just in terms of what his allegations about the arrest warrant are, the arrest warrant, it's a ROA 43. It says Principal Tinoco told him, referring to Mr. Anaya, that he needed to change his statement by adding that Coach Esteban Alegria was present in the locker room at the time of the incident involving the assault of a student. And so that is very, in my mind, very clear-cut language that suffices for 3605 of tampering with a witness. You are telling a witness to change the story, to add someone into this process or into this conversation that was not there. Now, I understand earlier, Judge Higginbotham may have made some references to coercion or that type of evidence, but the court needs to be mindful that this is the principal of the high school. Amaya is an employee of the high school. This is the employer in a position of power over an employee telling him that he needs to do it. And therefore, although in my mind, I think the probable cause affidavit is sufficient with that particular claim, but the record on appeal supports this court can find because of the different power dynamics between the two. And he's saying it based on this video affidavit that he needs to do it. So his immediate superior is telling him that he needs to do that. In terms of the coercion aspect, if the court wants to have some evidence with respect to that, that's where it is. But in terms of the Monell claim made against the city of Hidalgo, under Monell, Mr. Tinoco needs to have pled an unconstitutional policy existed, a policy maker knowingly created or tolerated the policy, and that the policy was the moving force that directly caused the violation of the right violation. And so here, the biggest issue, I think, Your Honors, and I find this confusing, but Mr. Tinoco attempts to say that there's some sort of constitutional right to be recorded by a stationary surveillance camera rather than a body cam or a iPhone camera, and he's turning this somehow into some sort of constitutional right that the district court nor I can determine where this comes from. I mean, it is a non-existent right. That he talks about it a number of times in his complaint. It doesn't set forth any specific violation of any constitutional right. And so, I mean, that's like arguing, for example, on a DWI stop that, you can only be recorded by the dash cam on the police vehicle, but not the body cam that's on the officer's person. And so they were being recorded. If he had issue with anything, I mean, whatever happened was recorded. It's just that he's objecting somehow to the form or the way that the recording takes place that seems to, he thinks, amounts to some sort of constitutional right. But the district court doesn't believe it exists. I don't believe it exists, and it just does not exist, Your Honors. And so because he didn't allege any particular unconstitutional policy that existed, his Monell claim cannot persist. And I don't even think we need to get to the rest of the elements, but even if we look at whether or not this policy was what was the driving force behind a right violation, I mean, how can being recorded by a stationary surveillance camera somehow afford you or show a violation because they use the iPhone camera instead of the stationary camera? I mean, it makes no sense. He didn't sufficiently plead an unconstitutional policy. There were conclusory allegations. He's not alleging some sort of pattern of conduct, and he's not specifically stating that similar incidents of conduct have occurred that resulted in some injury. And so with that, Your Honors, I believe that there's not a Monell claim under those facts. The only other thing that he said with respect to Monell liability, and it's on ROA 143. He says, Hidalgo Police Department has adopted a policy of conducting unlawful seizures, false arrest first, and ask questions later. He just keeps saying it in a very conclusory fashion. He's not providing a underlying set of facts to support those claims. And so, I mean, we understand that that's what his argument is, but in terms of a policy, there's no written policy. He's saying that there's some informal policy, but there's nothing in his petition that specifically identifies under the plausibility standard something that would substantiate a claim under Monell for this policy creating a violation of any constitutional right. And so, and even if he does talk about one specific instance of conduct, I know he refers to that a number of times in his petition, but the case law says it's nearly impossible for a plaintiff to show deliberate indifference based on a single incident. And he shows no pattern of conduct of these particular incidents with respect to these facts to establish any sort of claim under Monell. And so with respect to the other claims that he has made for hiring, for example, in order for him to establish a hiring claim for failure to screen, it depends on a finding that the officer was highly likely to inflict the particular injuries suffered by the plaintiff. And so there's really, I mean, although he does attach a lot of different documents to the petition, most of the things that he is attaching are all subjective complaints. There's no censure with a finding saying that this particular officer actually did something wrong. I mean, the presumption of innocence applies to everybody, including the officer Lozano. And so although some of these documents may refer to him doing some things, these are all based on subjective opinions of people that may have worked with him, but they don't rise to the level of actually making a claim. You can't say, I believe I was hurt in a car crash and I'm suing you for negligence. You have to say, I was hit with another car in a crash and I'm hurt. And so the subjective beliefs of these people in all of these attachments don't rise to the level of being able to assert a plausible claim for relief. And I just don't see how he gets there with respect to the hiring claim. And in terms of the training claim, under the law, Mr. Tinoco needs to plead facts that show that the city failed to train him. He says that generally, but he has to also show that there's a causal connection between the alleged failure to supervise or train and the alleged violation that he's talking about. And here, I mean, other than saying you didn't train this person to do what? I mean, that's our biggest question here, which is if he's talking about the surveillance camera as opposed to using an iPhone camera, how did failure to train this person to only use a surveillance camera result in a constitutional violation? I mean, none of this makes a lot of sense. I think the district court got this completely right. There's no causal connection between this alleged constitutional right with respect to the recording issue that we were speaking about. And then finally, Your Honors, in order to show a training and hiring claim under Monell theories, he has to show deliberate indifference. And, that this person has to be subjectively aware of the substantial risk of harm and then disregard the risk to the person that's injured. And so I don't see how this alleged constitutional right of recording somebody through a stationary camera as opposed to an iPhone camera, number one, it's not a constitutional right. Number two, how does it create any harm? And so with that, Your Honors, we would request that the court affirm the trial court's judgment and dismiss the claims that Mr. Tinoco's filed. And I'll let Mr. Lopez speak to you now. Thank you.
Thank you, sir. Mr. Lopez?
Good afternoon, Your Honor. May it please the court, counsel. Your Honor, Randy Lopez on behalf of the appellees, and I'll be speaking about the claims that were asserted against the individual officers. And Your Honor, I know co-counsel Mr. Escobar did address Justice Higginbotham's question about the threat and whether that's present on the face of the affidavit for the Malley claim. So I won't belabor that point, Judge. The I think what's more important is that under the independent intermediary doctrine, assuming that Officer Lozano, when he drafted this probable cause affidavit, presented it to the magistrate, if there was a question as to whether it met the elements, then the independent magistrate is certainly in a better position than Officer Lozano to make that determination. And I believe this court made that clear in Villarreal versus the City of Laredo, and more recently in.
But what about if Lozano was lying?
Yes, Your Honor, and that would speak to the Franks argument, Your Honor. I believe under Malley, it's just a presentation of an affidavit that's facially lacking probable cause, but under Franks, if the officer is lying, well, then the independent intermediary doctrine doesn't apply, Your Honor. But the only allegations that the appellant makes as to whether Officer Lozano is lying is that he's not saying, for one, Your Honor, Justice Haynes, he's not saying that Officer Lozano lied. He's saying that he omitted material, what he believes are exculpatory statements. But in the body of his pleading allegations, there's nothing to show that Officer Lozano, or any other officer for that matter, had any of these purported exculpatory statements before he applied for the arrest warrant. And I believe that's present in the record, Your Honor, when at paragraph 37 of the plaintiff's original complaint, or I'm sorry, First Amendment complaint, where Tinoco, the appellant, says, you know what, I've gotten these affidavits, and I'm going to give them to the police officers when I'm ready after I've reviewed them. There's nothing to say when, if at all, the appellant actually gave these purported exculpatory statements to Officer Lozano. And of course, I believe that's crucial to, even if they did have some sort of exculpatory information, which this court's certainly allowed to review the affidavits that were submitted, there's nothing exculpatory about them. The affidavits that were submitted, that the appellants made part of the record and central to his complaint when he submitted his first amended complaint, is that basically it's nothing to address whether or not Tinoco told the subordinate employee, Coach Amaya, to change his statement, which meets the elements under tampering with a witness. What the statements say is he didn't witness an assault, but that has nothing to do with the basis for the tampering with a witness offense that's asserted in his First Amendment complaint.
Well, he was arrested pursuant to an arrest warrant that alleged that a violation of Texas Penal Code 3605A, and that criminalizes coercing a witness or a prospective witness in official proceeding to testify falsely. And then the code goes on to enumerate the various circumstances, accusing people, etc. The last one of those, subpart F, is to take or to withhold action as a public servant, or to cause a public servant to take or withhold action. And I would assume that subpart F of the code under which this warrant was taken is what you rely upon.
Yeah, I believe it's what the magistrate may have relied on.
Yes, I don't mean you personally. You'd argue in the case that was the basis of the magistrate.
And you,
the latter part of that statute on which this warrant was issued, of coercing a witness, is or not, what that means is what I was zeroing in on. Because as I understood the facts, what he did was tell him, you ought to change your statement, in essence, in words of that. And that was the basis of it. all of this goes to the fact that you have a warrant, and do you look past it, and that warrant normally is the end of it, unless you, an O'Malley, take a look at it, the underlying facts of it, the basis of it. And that's where, so I'm zeroing down and drilling a little deeper to do that. I'm not suggesting that it's right or wrong. I'm uncertain of what this latter, there, subpart F of that statute is where you put this, to take or to withhold action as a public servant, or to cause a public servant to take or withhold action. Is it being a threat?
Yes, Your Honor, and of course, I believe, just when it's going back to the very basic of 36.05, it's a person commits an offense if he coerces a witness or a prospective witness, and if it's just an official proceeding to testify falsely, and just on its face, Your Honor, I think the appellant, the only thing he's raised is that there was no allegation of a threat, or there was no allegation of, or that otherwise the probable cause affidavit doesn't meet the elements for an official proceeding. But all that's just to go back to say that even if that was the case, Your Honor, the independent intermediary doctrine would insulate Officer Lozano at that point, because again, the magistrate's in the better position to determine whether.
But I suggest to you that I am talking about the qualification to the intermediary doctrine. Absolutely, the warrant is, no officer can, a valid warrant can be held accountable for that in the very limited circumstances. I'm not suggesting they're here, they're not here, but I'm trying to zero in exactly what the pivot point is, because as I understood what he said to the guy was, you ought to correct your statement. Now that was translated into urging somebody to commit perjury or whatever else, but.
Yes, Your Honor, and just to address that very briefly, Justice Higginbotham, he told him that he needed to change the statement to add that another person was in the room. Why that was, we don't know, and there's certainly no facts to suggest whether that would have actually made a difference in the underlying criminal investigation. But, Your Honor, Justice Haynes, just to circle back to your question as far as the falsity, because I do believe that as far as what the appellant suggests are the false statements in the affidavit, were not really false statements that Officer Lozano made. Rather, what the appellant posits is that the defendant Amaya actually made false statements, and that Officer Lozano was incorrect to rely on those statements. But that's not a claim under Franks, right? He's just simply interviewing the witness, this Coach Amaya, and saying, okay, I'm going to take your statement as a basis for my probable cause affidavit. So there's nothing to suggest that he should have done anything above or beyond that. And I believe we cited that in page 18 of my brief. And lastly, Your Honor, as far as the 14th Amendment issue, there's certainly no facts to suggest that there's a substantive due process right, and I believe my co-counsel did address it, to have a witness interview recorded by any particular type of means. And instead, Judge, what I would present to the court as well is that even if this court was to find for some reason that there is a substantive due process right to have a witness statement recorded, that there was certainly no clearly established law at the time that would have put Officer Lozano or any other officer that, by not doing so, was against clearly established law. And with that, Your Honor, happy to take any questions with the 10 seconds I have left. I'll concede the rest of my time. Thank you, Your Honor.
All right, thank you, sir. Mr. Tinoco, you have rebuttal time.
Thank you, Your Honors. I would note for the record that the witness statements that Principal Tinoco obtained from teachers and employees at school were provided to the school resource officer, who then provided those statements to the police department. Now, with respect to the cameras, I mean, the reason I put those on the record is because I was appalled by that. I don't see how they're not appalled by that the police department was covering up the cameras, whether it was to intimidate people, whether it was to, not document certain interviews if they wished, which I believe that was the case. But there's no reason for any police department to cover up their witness cameras at the police department. Absolutely no justifiable reason. And that's one of the reasons that it was raised, to show that there is this culture based on the information that we obtain. There's a culture of doing what you want, not doing the right thing, based on Officer Lozano, based on this case, which they could have easily, and they did try to talk to Principal Tinoco, but they could have easily, again, gone to question him, to ask him about what Guadalupe Amaya was saying. They could have corroborated the information. They could have conducted their independent investigation in a proper and manner to see what was really going on, instead of just taking one person's side of the story. They knew that Principal Tinoco was investigating these matters, and yet they went and they arrested him at the high school on purpose with the media. They contacted the media before the arrest because they wanted to make this into a big deal. Students knew that the principal was going to get arrested before the principal knew that he was going to get arrested. Teachers at the school knew that he was going to get arrested before he knew he was going to get arrested. So these are all facts and situations which are, as the court noted in a previous case, cues that are really absurd. These are absurd facts. The fact that they would arrest the principal in this matter shows the evil intent that they had in doing this. Now, with respect to the constitutional violations in this case, it was an unlawful seizure, unlawful arrest, and that all relates to the Malley situation, the improper training, improper hiring, improper supervising. All of these tend to lead that this is what led to the unlawful arrest.
You had sought to amend, I think at some point, did you, and that was denied. Was there more that you had contemplated to amend that would have augmented, if you will? I know you felt it was sufficient, but augmented some of the difficulty that the district court found?
Judge, we are asking for a remand for us to be able to proceed in this case, conduct discovery, conduct depositions, get more information on what exactly happened here. Other information that we were able to get, yes, we were able to get additional information that we haven't included in the amended complaint. That we are asking for this court to allow us to amend our complaint, because that was denied by the district court. So we are asking for that opportunity. We know something went wrong. I believe the defective affidavit has everything to do with it, and we would like to amend our complaint. Any other questions?
No, it's your time.
Thank you. Have a good day.
All right, thank you, sir. All right, that completes the arguments in this case. Thank you, counsel, for your briefing and argument. We will take the matter under advisement along with the other cases that we've heard this week. With that said, the panel will stand